Want to say good afternoon and certainly thank you all for joining another session of Apella Academy. Today's session is estate planning on reducing friction in estate planning. It's a really important topic because estate planning is a very confusing, complicated area of financial planning, and really excited for today's session in how to make this an easier task for some of you who maybe be putting it off for a while. I want to remind everybody that all of our previous sessions of Apella Academy, including things like Social Security or how to reduce taxes in 2025, any of our market commentaries, etc., they're all available and ready to watch on our website. So go to apellawealth.com. You can go to events and you can find all of our previous ones there. You can also find how to register for future events on our website as well. As I do each time, I like to remind you that if you find these sessions interesting, helpful, educational, it's likely that your friends and family would as well. So we encourage you to share. Once again, you can just forward links, forward recordings, etc., to people that might find value in this type of educational information. So if you have any questions during today's session, please use the Q&A function within Zoom. I will be monitoring that throughout, and I will try to get to all of your questions. If I don't, we'll do our best to reach out after the fact and get your questions answered. So now on to the show. I'm really excited for today's session and for today's speakers, and I'd like to introduce them all before I turn the session over to them. In no particular order, our speakers today are first, Audrey Johnson, who works in our Huntington Beach office. Audrey is a certified financial planner who discovered her passion for financial planning while in college studying business. She got involved with the Financial Planning Association and the literacy program on campus, and there was no looking back from that moment. So she's a rising star in her industry. We're very fortunate to have her on our team. So very excited for Audrey today. Thank you. Our next speaker is Kathy Parks. Kathy Parks is also a certified financial planner, and she works in our Knoxville, Tennessee office. Kathy and I go back a ways, and I'm proud to call her a friend. She's been practicing for nearly 30 years and has helped so many folks achieve their financial goals through her very deep consultative process. She dedicates so much of her time in the area of financial planning and estate planning specifically. She's a key contributor in her community. She works with so many attorneys, CPAs, and leads a lot of estate planning study groups in her area as well. So welcome, Kathy. And last but not least is Mark Prendergast, also from our Huntington Beach office. Now, Mark is formally retired, although I've seen no evidence of that, which includes his welcomed presence here today. Mark has spent over 40 years in our profession, leading our profession, really, focusing so much of his time in the area of tax and estate planning. Mark has sat on various boards, including the National Board of Directors for our Financial Planning Association. He's a regular educator at so many industry events and professional conferences. So we're really excited to hear Mark speak today. With that, I'm going to turn it over to the gang. And Mark, I think you are actually the one kicking us off today. So welcome, sir.
I am, and thank you, Jason. And with the magic of technology, we go from West Hartford out to Huntington Beach, and later we're going to kick that over to Knoxville, Tennessee. So that's kind of fun. So I'm going to start by making the statement that estate planning is not just preparing and leaving a will. If you have a will, your estate plan is not complete. So estate planning is an active process. We want flexibility while you're alive so that there's minimal friction while you're not. This estate planning process is a critical piece of your overall financial plan. Your Apella advisor can help you with this estate planning process. We want to help you monitor your estate plan and recommend changes through life's journeys. So let me start with a brief overview of what we're covering today. After my introduction, then we're going to go to Audrey, who's going to talk about what happens if you have no estate plan documents. Next, we'll go over the essential estate documents needed for your financial plan. Next, Kathy will guide us through steps to monitor and review and update your plan. Estate planning is not just set it and forget it. And then when we wrap it up, I'm going to talk about use of trusts, and Kathy will talk about charitable planning techniques. So over time, goals change and people change. Initially, maybe your estate plan says everything goes to the kids. Now, maybe your adult children are financially secure and you want to incorporate some charitable giving in your estate plan. Initially, maybe my brother Jimmy was named as the executor of my estate. But now I see Jimmy has a drinking problem and I don't think he's the right person for that. So things like this, these are reasons for reviews. I'm going to move to friction in estate planning. These are like 4 points of friction that I had identified. The first one would be estate taxes, things that drag on the estate plan and on efficiently passing things to your heirs. Estate tax is one, administration costs is another. Thirdly, I have income taxes. And last is family friction. So I'll start with estate taxes. So the estate tax is at 40% for the value of your estate that is above the federal exemption. So right now, the federal exemption is quite high, around $14 million per person. But we don't know if that's going to last, right? That's what the current administration has, and administrations come and go. But as an example, if it's a 40% tax and your estate is $5 million above whatever that exemption might be, if it's $5 million above the exemption, that's the taxable portion. There's $2 million that goes to the IRS. And I don't care if your estate is worth $10 million or $100 million. No one enjoys writing a check for $2 million. So Audrey will later discuss what the current exemptions are, a little bit of history on that. But my question is, will they stay this high? And as I said, for the next 4 years, I believe they're going to stay this high just because we have a Republican both in the executive and legislative branches. They control both. And so I don't see that that's going to be decreased. But after that, we don't know. And that's all the more reason to have flexibility. So next I have is administration costs. Those are things like the attorney, CPA, appraisers, the executor fees. There's also court filing fees. And in California, we have something called extraordinary fees. I don't know about other states, but if you have a normal estate that's in probate and you sell a piece of real property, then the attorney gets to collect extraordinary fees on top of their regular fees. So can we plan to minimize these costs? That's the goal. So while you're live, if you want to make some changes, we want to minimize the cost now. We want to minimize post-death, and also while you're live and you're making changes to your plan. Are there ways that we can avoid those additional attorney fees and other costs? The third one I have is income taxes. Our goal is for the client, first goal is for the client to maintain control of all their assets. And then secondarily, we want to minimize long-term family taxes, intergenerational taxes. If an IRA, I'll give you the example of an IRA. If you happen to be in a 24% tax bracket, but you know that your child or children happen to be in their peak earning years, and maybe they're in the 35 or 37% federal bracket, it might make sense for you to be paying some taxes now to save them taxes later. And in that example, some people know that they will never exhaust all of their IRA. And if they won't exhaust all their IRA, maybe now is the time to prepay some of those taxes. And it's beyond the scope of this discussion, but one such strategy is a Roth conversion strategy for you over time to be doing Roth conversions to keep you in low tax brackets so your kids don't have to pay in higher brackets. So, and the last one I've identified is family friction. It's potentially the very biggest cost. It can damage relationships forever. I've seen it happen. Is the eldest child the right person to be your executor? So what happens when a parent dies, we'll say the last parent in this example, and there's a number of heirs? Usually there's two questions. How much am I going to get? And when am I going to get it? And they're kind of in a hurry. And if you're the executor, You have to abide by all sorts of rules and laws and procedures. The ones who want the money, who aren't in charge, they don't understand that. They want the money now. And there's different personality types, and you probably recognize that. So another example in family friction could be, what if your brother is named as the executor, and those kids, they want them. And now you know that uncle, niece, and nephew relationship may be damaged. Maybe that's not the perfect person either. So identifying the right person is important. Maybe you should consider an independent person to be your executor, such as a professional fiduciary. In California, we have licensed professional fiduciaries. There aren't many states that have that, but all states, there are going to be people that function in that capacity. So a lot of times it's a CPA or an attorney, but you want to find one that specializes, and that's part of their normal practice, is to be a professional fiduciary. You don't want to name your CPA or your executor because they kind of know you and they know your family. You want somebody that does this as a regular part of their business because they know the rules, they know how to deal with family situations and family emotions, they know how to say no politely and navigate that landscape. Another example of family friction could be unequal distributions. Let's say you have a daughter who's single and she's a surgeon, and you have a son who's married, has 4 kids, and he's a school teacher. And you go, I think our son should have a little more. We want to help him more. And you understand that. If you said nothing, person dies, all of a sudden they look at the will or trust and they find out the daughter goes, I only get 40%. People equate dollars with love, and they're going to say, mom and dad didn't love me as much. The other side to that, or maybe a solution to that, would be to talk to the daughter about that while we're all here and have good relationships and conversation about, this is what we were thinking. Your brother struggles a little more than you do, and we were thinking about skewing a little more towards him. What do you think about it? I think your daughter may go, I see what you're talking about, and I'm okay with that. Or even if she said she's not okay with it, you've at least put her on notice, and you can decide, no, we'll just go 50-50, that'd be best. Or if you didn't go 50-50, at least she knew and she heard your reasoning for it. So communication is just so important. So let me sum up a little my friction analogy here, and I'll sum it up that really what we want to do is, number 1, reduce taxes. Number 2, have efficient administration. And number 3 is really to preserve those family relations. So now I'm going to turn it over to Audrey, who can tell us what happens if you have no estate plan in place, and that could be kind of scary.
Thanks, Mark. So you might think that you do not have an estate plan in place. Well, I'm here to tell you, if you do not have estate documents, this right here is your default estate plan, aka probate code. Now, for illustrative purposes, we're looking at California probate code. It's paperback. It has over 1,300 pages. It's weighing over 3 pounds. This is going to vary state by state, but the elements remain the same. If you do not make decisions for your estate, someone else will. So to flesh this out a little bit further, we're going to walk through a little scenario. So let's say you're unable to make medical decisions on your behalf. The court is going to appoint a conservator of the person for you. Let's say you can't manage your finances. Well, the court appoints a conservator of the estate for you. If you're unable to raise your minor kids, the court's going to appoint a conservator of the person and the estate for them. And let's say there's no direction about the distribution of assets, meaning you died intestate with no will or trust in place, then probate and intestate succession rules will apply. So, and ultimately, the court has the decision when it comes to your health, your finances, your minor kids, and your assets. Alternatively, estate planning documents are going to put you back in that driver's seat. So let's review what the basic estate planning documents are. We're going to start with a will, which is a legal document that specifies what happens to your assets, as well as names a guardian for your minor children. You're going to list what's called an executor, who's going to ensure that your will is carried out and that your wishes are fulfilled. So next we have a trust, which is a legal arrangement that allows for a successor trustee to manage your assets while you're either alive, and incapacitated, or after death. And generally this will avoid probate. That trustee is going to be the one carrying out your desires. Next, we have the durable power of attorney. So this is related to financial decisions. It's a legal document that designates an agent who has the authority to manage your financial matters on behalf of you. Now, we want to note that there's two different types of durable power of attorney. The first is an immediate, which comes into effect as soon as those documents are drafted. And then we also have a springing durable power of attorney, which springs into action when you have an incapacitating event. We want to make sure that you're aware if this is a springing durable power of attorney, you're going to likely need a doctor's note for certification that you are indeed incapacitated. And then finally, we have the healthcare directive, which is a legal document that outlines your preferences when it comes to medical treatment, as well as end-of-life care, in the case that you're unable to communicate or make those decisions. So you're designating an agent who is going to make those medical decisions on your behalf. So now that we've reviewed those basics, let's go back to the same scenario and see how that changes the flow. So now the estate plan, right, is in your way that it's being conducted. So you can't make medical decisions. Well, not to worry, because you have that current advanced healthcare directive in place. You've nominated your agent and you've educated them on your wishes for your health. You can't manage your finances. Well, you have a current durable power of attorney in place and you've nominated that agent and they're able to execute your desires. You can't raise your minor kids. Well, you've nominated your guardian and you've revisited this issue regularly to ensure that it's an individual you want taking care of them. And then finally, no direction about the distribution of assets. Well, not to fear. You're using a probate alternative, you've executed your will or funded your trust. So that's in place and that flow of assets is going to follow your desires. By doing constructing these estate plan, you're circumventing the chaos and the uncertainty of a court-dictated decision, and instead you're upholding your desires for your well-being as well as ease of mind for those that you really care about. One more item that we want to review is called your digital estate plan. Now that we've entered this digital age where we're using online accounts and our digital footprint continues to grow, we need a system or a structure to deal with these accounts once you die and the accounts remain intact. So you might be thinking to yourself, what is a digital asset? You might be familiar with Bitcoin and you think to yourself, oh, I don't have that. I don't own an NFT or the like. But digital assets could be as simple as the login to your phone or the passcode for your computer, the account related to your Instagram. So this does apply to each one of us. Now, what has resulted from just needing to manage these online accounts after death is called RUFADA, or the Revised Uniform Fiduciary Access to Digital Assets Act. And this is a law that provides the executor of an estate or an attorney with access to someone's online account after death or incapacitation. So that's extending those traditional powers of attorney given to trustees or attorneys to manage the tangible assets. It also includes those digital assets as well. So you can include this language in your will, your trust, your power of attorney. And we also recommend that you keep an updated record of all of these passwords. And Kathy will get into this in more detail. One solution to consider is a password keeper online in some type of vault. The final note that we have, we want to make sure that we emphasize is if your estate planning documents are over 5 years old, they likely do not include language that addresses your digital estate. So it might be a good time to review together with your Apella advisor. So with that, I'm going to pass it over to Kathy, who's going to walk through the next steps once you have those documents drafted.
Thank you, Audrey. I appreciate that. So, like Audrey said, we've got our documents in place. That's your will and powers of attorney, possibly a trust. And I think one of the things Mark said is really, really critical is that when you have those documents executed, it's not the end of the estate planning process. There's a lot more follow-up that we need to do. So we want to talk through that. The first thing that you want to do is often your attorney will do a cover letter or some kind of letter of instruction to talk about what needs to happen now that the documents are executed. And we'll talk a bit more about that in detail. The first thing to do is to figure out where will you file your will and powers of attorney. Could be at your attorney's office. Some attorneys will hold original documents in their office. Could be a secure location in your home, like a safe or a locking filing cabinet, something of that nature. Could also be a safe deposit box at your local bank. One note is that you must probate an original will. So where the original will is an vital part and critical that your executor know where that is. In Tennessee, at least, when you're transacting real estate, you also need the original power of attorney. So you need to figure out where those originals are going to live, and then let your agents know, your executor for your will, your attorneys, in fact, for your powers of attorney, to know where are those documents. Also, it's common for you to give copies of those documents to your agents, especially powers of attorney. If you think about it, for instance, if I am the attorney, in fact, for someone who happens to be out of the country or just not available for one reason and I need to transact on their behalf, it's really valuable for me to have a copy of that power of attorney so that I can go ahead and do that. If you think about healthcare powers of attorney, often that's going to be needed in an urgent manner. It might be a health event, could be an accident of some variety. So what I often recommend to my folks is that your agent have an electronic copy of that on a device that would be with them in case they're called to the hospital in an emergency. So again, you want to provide copies to your agents, but as well, it's really valuable to provide copies of especially your financial power of attorney to your Apella advisor and their team so that we can see if there's any follow-up actions that are necessary with your accounts or anything with your financial plan, and we can assist in that. It's also really handy to have your medical team have copies of your medical power of attorney, your healthcare power of attorney, your advance directives. So it's a great idea to have your teams have copies of those. And then one of the last pieces in regard to your documents themselves is that we suggest that you complete what we call the Apella Estate Organizer. We created this small organizer as a service to our clients and our communities because what we found was those really big, sometimes over 100 pages of organizers are just really daunting to be able to fill out, and stuff changes. The location of your documents, passwords, your desires may change. So it's really arduous to be able to fill out one of those large organizers. So Audrey, can you jump to the next slide for me, please? Thank you. And folks, I realize this is really hard to read. This is just a screenshot of the organizer that we've created. And let me walk us through that just a bit. So really, this is the critical stuff that your executor or power of attorney might need to know if they were to need to act on your behalf. So in the top left, what we see is your name and then access information. Essentially, what's the password to your cell phone? What's the password to your computer? What's the normal location of your wallet in case somebody needs a medical card, a Medicare card, a driver's license, something of that nature? Where are your keys? The keys may be the way that they get into the house so they can get into the filing cabinet to get to the will. Location keys to your business, offices, things of that nature. And then as Audrey mentioned, it's really important that your executor or power of attorney know how to get to all of those passwords to all of those accounts that we now all have. And there's a lot of different ways to do that. Password managers are a really good way. Some folks do a password protected spreadsheet. Lots of folks do it on paper. So it's really important that you have a system for that and you note that on your organizer so that your executor or attorney, in fact, can act on your behalf. The next section on the left side is just where are your records? Are they electronic? If so, what device do you go to? How do you access that device? And generally, what should we find in as far as electronic documents in your records? Are there hard copies? So that might be, for instance, your tax returns, having hard copy versions of or having hard copies of your tax returns. Again, where is that and where are those records? How do you access those records? Is there a key to a filing cabinet? Whatever the case may be there, and what are those records? So it could be things like marriage licenses, birth certificates, all of those, the stuff that we still have in paper. On the bottom of the left section is safe deposit box. Do you have a safe deposit box? Do you have more than one? If so, which bank, which branch? Where is it? What's the box number? What's the address of the branch? What's the phone number? Where's the key? That's critical. That's often like, we know there's a safe deposit box and we know it might be at XYZ Bank, but where's the key? Which branch and where's the key? So that's a critical part to make sure that your especially executor understands. On the top right, if you have a safe at home, that's important to understand. Where is it? Where is the key or what is the combination and generally what's in that safe? And then most of the right side is if something happens to me, who do you need to contact? That might be your appellate advisor, your CPA, your attorney, maybe an insurance person. If your agents are not family members, it could be family members, close friends, neighbors, things of that nature. And then the last two items are if you do have an estate organizer that is larger than this 2-page item, then just where is that in a description of that? In creating this, we did find a story of a lady who created one of those, meticulously filled out one of those large organizers, but didn't tell anybody she had done that. So it didn't help her executor in that case. And then last, but certainly not least, is where are your wills, powers of attorney? What's the password or key or combination to get to that? It could be your attorney's phone number if your wills and if your documents are with your attorney, and when were they executed. So this is a wonderful kind of succinct document. You can just reach out to your appellate advisor and he or she and their team can get this to you. I will tell you that we're in the midst of a transition with our printers. So if you're requesting a hard copy, it might be just a week or two before we can get you a hard copy with our transition there. The other piece I will say about this is under no circumstances should you complete this, scan and email it on your Gmail account to your executor because it contains very, very sensitive information. Your agents need to have this information, but it does not need to be in cyberspace. So that's a really, really critical part of the organizer. And again, we hope this is helpful to you. And if you happen to be the agent for someone else, feel free to request copies for them so that they can complete it for you. So when the time comes for you to take care of them, you've got the information you need as well. Audrey, let's go to the next slide then, if you would, please. Thank you. So now that we've got the documents are executed, everybody knows where they are and they're stored properly. The one last critical piece is making sure that your assets are titled or your beneficiary designations align with your estate plan. So for your taxable accounts, think about things like bank accounts, brokerage accounts, real estate, other assets that need to be titled. The way those are titled will either flow through the titling or flow through your will or trust. So for instance, let's say that my will leaves everything to my husband, but my bank account is payable upon death to my brother-in-law. Well, my brother-in-law is going to end up with that bank account, not my husband, because of the titling. If another situation might be as a result of the planning, my husband and I have always had joint assets, husband, wife, with joint tenants with rights of survivorship. In that case, the asset is going to flow directly to the survivor of that account, not through your will. Your estate plan might say, hey, we want it to go for tax or other purposes. We might want it to go to a trust for husband, a trust for wife. So in that case, you might have to change the titling of the bank or brokerage account or real estate to be husband revocable trust, wife revocable trust. So it's critically important to make your estate plan and your documents actually operate to update the titling of your accounts to match that. Typically, you're going to find that in your attorney's cover letter, but if you don't, it's an easy call to just ask them how account should be titled. Similar with beneficiary designations, your retirement accounts, annuities, life insurance, all of those, they don't flow through your will, they flow through those beneficiary designations. So a common situation might be, I have an IRA, I want my husband to be the primary beneficiary of my IRA, but the attorney recommends not my minor children as contingent beneficiaries, but the trustee of a trust for my minor children that's contained within my will. So again, updating the titling of your accounts and your beneficiary designations to align with your estate plan is a critical part to make it work. And that's really where your appellate advisor and their team can shine, because they can work in collaboration with your attorney and make sure that those documents that you spend all that time and energy on are actually going to operate the way you'd like them to. One last bit about really wrapping up the estate planning process when you're updating documents is it's a great idea to update your net worth statement. We do that as a part of our financial plan, so you can reach out to us and we can get you a copy of your net worth statement or update it if it needs to be. And we suggest that you just include that with your Apella organizer, because what that does is it gives your agents a map, right? I know that there's 2 banks, 6 bank accounts, or this brokerage account or that IRA. So it really cuts down on the treasure hunt that an executor or an attorney of fact has to do if they have to act on your behalf. So I'm gonna, excuse me, I'm gonna turn it over to Mark, and he's going to talk about the use of trusts post-death. Mark, take it away.
Thank you, Knoxville. So thanks, Kathy, for that. So use of trusts post-death, those are called testamentary trusts. So there are dozens of types of trusts. We're going to focus on those that might apply to you, the audience here. So these testamentary trusts, while you're alive, you can change them because usually they are brought into existence based on language in your will, or if you have a revocable living trust. If I say will, I'm going to use that, but that if you're in a state that favors revocable living trust, we're just going to use those synonymously. So while you're alive, you can change them, but upon your death, no one can change the rules, and we call that irrevocable. So they become irrevocable upon your death. So why create a trust? And why should it be irrevocable at your death? And the reasons are predominantly around protection. You want creditor protection. So if your child inherits something through trust or in trust, and the child happens to go through bankruptcy, the bankruptcy court cannot seize those assets. Those are protected for your child, and that provides additional support for them for the rest of their lives or whatever term it happens to be. Creditors, in this case, I'm going to call it your child goes through a divorce, and by keeping it in trust, you're not enabling that person, your child, to commingle it, and then it becomes a marital asset, and then assets that may have been generational may have come from your parents down to you, down to your kids, and also if they got commingled, maybe half of it goes away, and here we're trying to protect that so it stays within the bloodline. Or any kind of lawsuit. If your child gets in a car accident and they happen to be at fault and there's a very large lawsuit, again, we have these assets that are in trust. And the last thing I'll mention is like self-infliction. If you have a child that has known substance abuse problems, or maybe they're a spendthrift, they get money and it's just gone, and you want to have a little bit of control after your death, you can put somebody else that has controls and levers that will guide them in terms of how they can distribute without letting the child damage themselves. So I want to discuss a couple of common types of trusts, and I have those, listed here on the slide. We're going to start with a marital trust. And typically on a marital trust, its primary purpose is to provide lifetime income or lifetime support for the surviving spouse. And then secondarily, we want to preserve the principal for the children. So I'll give you a sample of some language. And here I have husband and wife, and politically correct to kill off the husband. Usually when I'm dealing with client couples, the husband goes, yeah, that's fine. And the wife just goes, yeah, that's fine too. She doesn't like to go first. So in this example, it could be the husband dies and its income goes to wife for life. And if the income is not sufficient to provide for her lifestyle, we have some principal distributions that can be made. But the remainder goes outright to the kids pro rata. If you have 3 kids, it would go 1/3 to each. It doesn't have to be 1/3 to each. You can design it any way you want to, but this is like the prototypical type of marital trust. Income for life, remainder goes down to the kids. So, but why not just give it outright to mom, and she can deal with it, and she's going to take care of the kids. So here are a couple. I have 3 bullet points here. So if you have children from a prior marriage, maybe you have 60-year-old couple, maybe they've been married 25 years. We have a long-term marriage, but each of them has a couple of kids from a prior marriage. And if one spouse dies first, which typically happens, then the other inherits it all. If you have any sort of, there can be step parent and stepchild relationship problems, or just the natural inclination for a parent to favor their own natural children. So you can avoid that by the person that dies first, their portion of the marital estate goes into a trust, provides support for the surviving spouse. And when that surviving spouse passes, then the assets go down to the children. So that's example 1. Sample 2 is remarriage risk. And I usually find that the wife is more concerned about this. And I'll give an example of a 50-year-old man who loses his wife to cancer. He remarries a 25-year-old about the age of his children, So now we have a new wife on the scene, and he is influenced to make his new wife a joint owner on all or the majority of the assets. All of a sudden, there's this potential for that the kids will never see those assets, when the wife's, the original wife said, I want our kids to get my assets. Once you're done, I want them to get it. So if half of the marital assets are put into a trust, the wife's trust, who has deceased, then there's some controls on income to the husband, let support him, but upon his death, then it goes down to the children. And the last example I have here is high net worth asset protection. My example here is we have a $15 million joint estate. I'm going to assume we're going to divide that 50-50, and I'm going to put $7.5 million. The husband dies first, $7.5 million goes into the husband's trust, the decedent's trust, and 7.5 is the wife's, and she can do whatever she wants to. She can change her will, anything she wants to with her share, but her husband's share is locked into a trust. So I'm going to give this story is a real story from one of my clients that happened about 10 or 12 years ago. About 2 years after the husband died, the widow goes to the car wash. A gentleman drives the car off. He has it backed in so she can put it in drive and easily exit the car wash. She gets in the car, and what does she do? She puts it into reverse, kind of automatically. He happens to be standing behind the car, and she steps on the gas. Makes me shiver when I think of this. Pins him against the cinder block wall and breaks his femur. So you can imagine, so luckily nothing happened, everything got settled, but you could imagine having a major lawsuit for loss of future earnings, for pain and suffering. And in this example, she has her assets, $7.5 million, is exposed to a lawsuit, but $7.5 million, her husband's side, is locked up in trust. If hers is all taken away, at least his is there to provide support for her for the rest of her life. And it's going to be the remainder, it's going to go to their children. It won't all be taken away. So luckily we didn't have to face that. So I have a couple other uses for irrevocable trusts. A special needs trust, if you have a child or a grandchild that has special needs and you want to have some additional support for them, If you gave it to them outright, they have to consume all of their assets, spend down before the government's going to support them and give them benefits. They're going to have to pay for the benefits. Well, if it's in a special needs trust, the government benefits will continue. And typically what happens is the special needs trust lasts for the life of that child. And once they pass, there's a remainder, and the remainder ends up staying with the family, getting distributed to siblings or whatever heirs that you happen to want them to go to. The second one, heirs with addictions. I already covered that issue, so I'll just skip down to minor children. And so you could have, we'll say both parents can be taken out in a car accident and we have minor children, or maybe it's a single parent and the single parent has an accident, cancer, whatever it happens to be. But when you have minor children, number one, if they inherit things outright and they're minors, it goes into a conservatorship, which is a legal nightmare. It's just no fun. I did that with my nephews when my mother passed. You don't want to do a conservatorship. All court reporting, attorneys, CPAs involved. So, nor do you want an 18-year-old inheriting, once they turn 18, they inherit $1 million or $5 million or whatever it happens to be. That's generally, we don't want that happening. So, so if we have it in trust, so typically trust for minor children, they go something like this: provide education and support through the age of 25. At the age of 25, give them 1/3 of the trust, and then keep the rest in trust until age 30. At age 30, whatever's left, give them half of what's left. And then at age 35, give them the rest. It lets them, it provides for them, it gives them the opportunity to make mistakes and recover and learn from their mistakes. And hopefully there's no mistakes just to start with. So, and then the last point I want to make is old estate documents. If your will or trust was drafted before 2013, for sure before 2013, you should really have it reviewed. Major tax and estate law changes effective 2013, another law in 2017, major changes there. And your provisions, especially if you have testamentary trusts provided in your will or trust, major changes, and those should be reviewed, absolutely. So with that, I will kick it back to Kathy to talk about some charitable strategies.
Thank you, Mark. So we want to talk about charity because often charity can be a part of a person's estate. As Mark said, if you have plenty of assets and you're giving everything that you feel you want to or should give to your kids, and there's more and you want to give to charity, then there are specific tax benefits to giving to charity, and particularly from doing so from specific assets. So let's talk through that a bit. We've talked a lot about different kinds of friction, and one of the pieces of estate tax that eliminates the friction is the fact that charities are tax exempt. They're tax exempt for income tax purposes, as well as estate tax purposes. So any assets that you give to charities through your estate are going to be estate tax free. Now, it's important to check with your attorney on estate taxation because rules do vary state to state as far as that's concerned. On the income tax front, there are lots of efficiencies that you can create by giving to charity and giving particular types of assets to charity. So if we think about your traditional, not your Roth, but your traditional retirement accounts, if I give those to my children or my spouse, they're going to have required, and by give, I mean they are the beneficiaries of that after my death, then they're going to have required minimum distributions. They're going to pay ordinary income tax on those distributions, and that can be up to 37% federal and plus possible state income tax. If I gift that or make the beneficiary of my traditional IRA or traditional retirement account a charity, they do not pay income tax. So there's no income tax to be paid on that distribution. So one really great strategy is if you have a portion of your estate that you want to go to charity, you can make that charity beneficiary of your traditional retirement accounts not, you don't have to do the whole thing, but whatever amount you want to give, you can make the charity that beneficiary. And that's an easy change to make. It's just a matter of getting with us, getting with your Apella advisor. You can change that IRA beneficiary without having to update your wills or trusts. It's just an easy form to sign. And if you want to change from charity A to charity B, again, you just sign the form. If the numbers change over time and you want to change the percentage, again, just easy to change. If you think about your taxable investments, so let's think about this. So I have, let's say for instance, I purchased IBM stock at $10 per share years ago, and it's now worth $50 per share. If I gift that during my life, the cost basis carries over, and the person I give it to, let's say it's my children, if they sell that for $50 a share, they're going to pay on capital, they're going to have a realized gain of $40 per share for that IBM stock. But if I hold it until my death, I bequeath that through my will, and it's $50 as of the date of my death. They get a step up in basis. They can sell that stock for $50 a share and have no capital gains and pay no tax. So as you can see, it's really a cool strategy to be able to give the income tax free assets through your traditional, your retirement accounts, and give the taxable investments to your heirs so you get that step up in basis and reduce capital gains tax. It's really cool. One small part about charitable remainder trusts is that's a irrevocable trust where you donate appreciated assets to a trust. There's an income stream for a period of time, typically 20 years or someone's life. It could be you or someone else. And after that period of time, the remainder goes to a charity. What that does is it reduces income taxes because you get an income tax deduction upon the funding of that trust, and it removes those assets from your taxable estate. So it's helpful on at least a couple of levels there. And one last note about charity is that you can donate if you feel, if you're young and you're not sure what charity you want to give to, or you're not sure if it'll be appropriate to give to that charity, whether it be an amount or that specific charity. You can give directly to charities, but you can also give through donor advised funds, which allow you to put some parameters around when those assets are distributed, who has controls over the distribution of those assets. And they're really wonderful tools, not only in life, but also as a part of estate planning. And folks like Schwab's charitable arm, DAF, Giving 360, Fidelity, Vanguard, all of the big custodians have a charitable arm where you can establish a donor advised fund. So with that, I'm going to turn it over to Audrey again so she can talk about some of the provisions of estate taxes.
Thank you, Kathy. So as we come to a close of just the content that we've run through, we're going to look really briefly at the current transfer tax rules. So as Mark mentioned at the beginning, as it currently stands, unified federal estate and gift tax exemption is set to sunset at the end of 2025. So it's cutting in half the current exemption amount of 14 million. Now, given our current administration, we will likely see the Tax Cut and Jobs Act extended another 4 years as part of the big, beautiful bill. But of course, we don't have a crystal ball. We can't say this with absolute certainty. So we continue to monitor the current environment as we just consider estate planning opportunities for our clients. So you'll note that maybe you're not on the hook for federal estate taxes, but some states do have lower exemption amounts that you should be aware of. For example, Oregon has the lowest exemption amount at just $1 million. So if your state is over $1 million, you're going to be at risk of paying 10 to 16% in marginal taxes on top of if you owe any federal estate taxes. So again, be aware of this. This varies state to state. You might just write it off and say, oh, I don't owe any federal estate taxes. That might not be the case on the state side. So when it comes to annual gifting, you're able to gift $19,000 to an individual each year. So as a married couple, this doubles your gifting ability to $38,000. This is a pretty powerful tool when it comes to reducing your estate. Again, year over year, this is something you're able to do. without paying or causing, recall that the unified credit, right, is reduced dollar for dollar by any taxable gifts that are made, but you're able to gift that $19,000 per year without affecting this. We'll also want to note that inherited assets, right, I'm sure you're very familiar with this, receive a step up in basis at death. There's a lot of planning potential here, which is why we note that, of course, gifted assets gifted during your life receive a carryover basis, and we often don't recommend this as inherited assets with that step up in basis has the most value when it comes to just planning for assets. So as we're bringing this to a close, we've cruised through all of our content. We thank you for giving us your attention. I'm going to hand it back over to Jason to just moderate any questions that might have come up during our time. So thank you.
All right. I appreciate that. I am attempting to change the view on the screen right now so that we all can be on together, which I hope is happening. Zoom changed their settings on me. So for those of you who have noted, at different times, I've had to move the spotlight around. So I pray that everybody can see everybody now, because we're going to open it up to some of the questions that are in the chat box here. So I am going to start with this question. In no particular order, Kathy, I might just kick this one to you first.
Sure.
Does my will and trust need to be updated or revised if I move to a different state?
The likelihood is yes, that you do need to update your will and or trust. It's going to depend on, typically your will need to be updated or re-executed. Trusts may be a different matter, but the easy answer is reach out to your Apella advisor. They can let you know. And if you are also, just to note, moving to a different state, your Apella advisor is a great person to reach out to and find a new attorney in case you need to find another one.
Mike was wondering, he is a healthcare proxy for a friend. And he was wondering, does he need to do anything like sign a HIPAA form to be able to get his medical information to make fully informed decisions on behalf of his friend?
So what I would say is that your friend has to, the person for which Michael is the agent needs to give HIPAA authorization. And if you've been to the doctor lately, you see that they ask, who can we disclose information to? That would be your attorney, in fact. The other piece that I would say to Michael is, if you aren't intimately familiar with your friend's medical conditions and preferences, it's a great idea to just sit down and have that conversation of, like what kind of medication, what are your medical situations? For instance, I'm allergic to sulfa drugs, so it's really important that my attorney, in fact, know that. And then some things about preferences of things that I might want done or not want done. So it really is an important conversation to have with your attorney, in fact.
Fantastic. Audrey, Jim asks the question, how do I find an attorney that's right for my particular needs?
That is a great question. So how it operates in our Huntington Beach office here, if we have a client who's reaching out and is curious about partnering with a great attorney, what we'll often do is look a little bit closer at their situation. So if they have maybe a more complex planning opportunities, then we're going to make sure that we partner with an attorney who's familiar with just a lot of moving parts in managing larger estates. And alternatively, if it's going to be a really simple, straightforward estate planning documents, then we'll make sure that we're taking that into account so we can find an attorney who also just meets the fees that our client is willing to pay. So it varies client by client, but we want someone who's going to be collaborative. That's an absolute.
I love that. In fact, somebody in the chat said what a great experience they had working with their Apella advisor and their estate attorney collaboratively. So that's a real shout out to that particular advisor. Mark, are you good to go? Can I ask you a question now? Can you hear me okay?
Yeah, I can hear you fine.
Okay. All right. So this particular question is from Andrew, and the question reads, can I create a trust myself and get asset protection?
That's a really good question. So by and large, you cannot. We call that a self-settled trust. You can't put your assets and protect that from creditors. So the example I gave you, like in a marital trust, it's really, I'm saying dad is putting the assets in trust. So dad did it. The couple didn't do it. Dad did it with his share of the assets, and they don't belong to mom. They belong to the kids, really. They are the remaindermen, so they're really the ultimate owners of it. Mom just has temporary rights to it. So that's how you get asset protection. There are a few states that have these asset protections that can be a self-settled trust, but I mean, you have to be 50, 100, a billion net worth to be able to do this. Go to, I think Nevada and Wyoming have these kind of trusts, but by and large, the answer is no. And you just find other ways to get asset protection. Some trust, your own trust for yourself. Insurance, big umbrella policy is probably the number one way we do that. I guess in LLCs and things like that.
Okay, thank you. Kathy, maybe I'll kick this one to you. And I'm going to try to summarize the larger point here. This is from Robin, and a friend of hers asked her to be executor of her estate when she eventually passes. She is unclear how complicated of a process that is. And, what should people, I'm going to kind of riff a little bit there. What should people be expecting from that process of having to be an executor of an estate?
Well, I think it depends on a few things. One is what state, because the probate, it's all state driven. The law is basically state driven. So which state you're in is really important. The complexity of the person's situation is also extremely important. Do they have business interests? Do they co-own things with folks? Do they have everything neat and tidy? Or is it a mess? I mean, are there stock certificates all over the house? So if Robin is not sure of how complex it might be, how complex the situation would be, I would suggest getting with her friend, his or her friend, and saying, okay, well, let's go through your situation together and have some familiarity with the situation. And then Robin can make a determination of whether or not they're up for being executive for that person.
Love it. Thank you.
Sure.
Daniel asks for estate tax exemptions, is the amount determined by the state the deceased lived in or the state the receiver lives in? Mark, maybe you can answer that one.
I guess we're talking about estate, state.
Correct. Yeah. I think that's
estate
what's
tax and inheritance taxes.
correct. Yep.
I don't know. We'll start with that because California, that's the only tax we don't have. There's no inheritance tax and no estate tax on the state side. But my impression would be that it's going to be where the decedent was. That's who's controlling the estate. I don't think it's going to be on the person that receives. Person that receives, they may have to pay that other state, but it's going to be, I'm pretty sure it's going to be determined by the state law in which the decedent lived.
I don't remember how many, Kathy, Audrey, maybe how many states actually have a tax on the recipient of an estate at this point? It's very few, right? I mean, is there
Audrey,
any?
is it,
Yeah, I think it's
Five or
close
six?
to, it's either 10 or 13. I know
yeah,
Pennsylvania is
I
one
was
of them.
thinking 14, and so and I would just add federal, obviously the exemptions federal, it doesn't matter what state you're in, but
Mhm.
state either inheritance estate tax or inheritance tax estate is going to vary by state. So there are a couple of states where it depends on where you live, not where the decedent lived.
Okay.
I'll add to that. I mean, there's some like pretty simple in Oregon, I believe, pretty simple gifting or techniques. Like if you just do deathbed gifts, if you gift, it's out of your state. There's no gift tax. So you gift the assets, get yourself below the exemption, something like that.
Mhm.
Let's see. Marvin asks if we have an estate planning attorney on staff. We don't technically, but we collaborate with so many across the country. So I would definitely reach out to your advisor and ask that question on who they recommend. Another question came in: how can my financial planner facilitate a family conversation about my estate and legacy plans if I'm nervous about doing it on my own? And I'll leave that one to whoever speaks first.
Wow.
So the question is like, how can your financial planner help to facilitate this family conversation?
Mark?
I would say we are not all trained in that. And so I think having a good seasoned financial planner would be a good first start. And if your financial planner happens to be on the young side, there's lots of us old folks around here that we support each other. Absolutely. Kathy and I, she's in Knoxville, I'm in Huntington Beach. We talk all the time. And so we support one another, and I'm sure we could facilitate that.
Audrey, do you want to add something? I've got some to add to that.
You go for it, Kathy.
Thanks. What I would say is it's a wonderful conversation to have in collaboration with the attorney, because the financial advisor, financial planner, and the attorney are coming at it from slightly different viewpoints, and they have different and complementary skill sets. So it's a lovely thing. And typically it might be have the conversation with your financial team, meaning your attorney and advisor first, get the strategy together about what conversations need to happen with family, and kind of let it unfold and lead you from there.
I'll add to that. I mean, because I've done that with families, and I think the important thing is you don't talk about dollars. You're talking about this is generally what we have in, we have an investment account, we have a rental property, we're talking generally, we're looking at, it's going to stay in trust for mom while if I go first, and then you're going to get it 50-50. You're just talking generalities, unless, we have another one, a client just 93 years old, just died a month ago, but her son had one child, and so he was intimately involved in everything, and so it all depends on the situation. But family discussions and that kind of communication is really healthy. Stay away from the dollars. Talk about process.
A shameless plug here for later in the year. Kathy mentioned in her chat today about charitable giving opportunities, et cetera. We've got another webinar coming up, I think November, on charitable giving, which I would encourage you, if you're interested in that, to tune more into. Also, check back with your financial planner. And then we're having kind of generational wealth transfer conversation in December. So that's another really important one with a lot more detail to come, because that is a really complicated area, and a lot of touchy family intricacies happen in those conversations. So we're excited for both of those future events as well. We're a couple minutes over time right now, so I think the rest of the questions we'll do our best to get to you all individually. I do want to thank everybody for attending today's webinar. We appreciate the interactivity that you provided with us, some great questions. We appreciate your attention. And, like I said earlier, please, please, please share this with anybody who might find this valuable. And I assume that everybody that in your inner circles, family, friends, they all have questions about estate planning. It's a very complicated area. Nobody likes to talk about it. So share this with them, get that conversation going. And to all of you on the screen with me now, thankfully all on the screen together, Audrey, Kathy, Mark, pleasure as always. Can't thank you enough for sharing your expertise and knowledge with everybody. We really appreciate all the effort and time that you put into this. Thank you so much. And we look forward to future events with all of you.
Thank you, Jason.
Thank you, everyone.